Hi everyone, welcome back. So in this session we are going to discuss about the need or necessity of private international law. So what is private international law and why do we need private international law? When there is a situation which makes it necessary for the court to refer to or to examine a foreign system of law in order to give a proper decision, there we need private international law. And why do the court need to refer to a foreign system of law? So that is when there is a foreign element. So according to Cheshire, that part of English law known as private international law comes into operation whenever the court is seized of a suit that contains a foreign element. Usually, the cases that come for trial before the municipal courts are those whose elements are internal. So, municipal courts are those within the country, those courts within the country that has local jurisdiction. Those issues are always internal. Now, there are situations where the court experiences foreign element. So, we keep referring to foreign element. What is foreign element? Foreign element can be that either the plaintiff or defendant is a foreign to this court. So, for example, if we are giving a case to an Indian court, and if either the plaintiff or defendant is not an Indian citizen, is a foreigner, that is a foreign element. Or in another scenario where the cause of action has occurred in a foreign state. Now that is also foreign element. So that is what is foreign element, and whenever there is a involvement of foreign element, there is a confusion or an ambiguity as to which law is to be applied, and that is when we come across private international law. So, in a case, there is a foreign element if it has some contact with a foreign legal system. If one or other element of the suit is connected with some foreign country, there is foreign element. So, foreign element is necessary when we need to apply private international law. So, does that mean that whenever there is foreign element, we are going to apply private international? No. We do have public international law as well as private international law. And uh, as the name suggests, everyone would infer that it is an international law. Public international law is international law and it governs the relations between the sovereign states in the international scenario. The private international law also deals with foreign element and also governs the relationship. But is public international law and private international law the same? No. Private international law is actually a municipal law. It is different for each and every country. But the public international law is the same. Private international law is different for each and every country, and that acts as a municipal law. What private international law does is that it lays down a foundation to decide or determine which countries or which lands municipal law shall be applied. So, private international law is a municipal law. So, don't get mistaken by the wordings saying that private international law. It is said it is international law, but it acts as a municipal law, and that is the reason it is also called as conflict of laws. So private international law is applied when there is a conflict of laws, that is there are more than one state or one foreign element involved. There is jurisdiction of more than one state here, so there is a conflict as to which law is to be applied. That is conflict of laws, and that is private international law. In a general scenario, when we are moving to the court, we apply lex fori, that is the law of the land, where the law of the forum, that is where the law of the country where the court is situated, is applied. So if we are applying lex fori in a case with foreign element, what happens? There will be a lot of injustice, and this would be against the principles of natural justice. What is wrong in one country might not be wrong in another country. What is taught in one country might be a crime in another country. So if we have remedies as compensation for tort, but what is if we are moving for compensation and we are applying the law of the forum, and at the forum, if it's a crime, there is no compensation available. So there are many kinds of injustice that may happen while applying lex fori. So it is important to decide which law is to be applied. All these decision determination is governed by private international law. So the invariable and inflexible application of lex fori in all cases would lead to gross injustice, and this is one of the main reason why we need a private international law. Now, it is not necessary the transaction should have taken place in a foreign country in order to invoke the jurisdiction of the other country, nor is it necessary that the parties should be domiciled there. Now, in India, we mostly follow the English, the law of the English. So, what I meant is, in India, the private international law of India is very similar to the private international law of England. But what's the difference is that in England there have been various modifications, various amendments. Those amendments have not yet been brought into action or implemented in India, but it might be in the future when there is a need, such a need arises. So the basic structure, the basic foundation is exactly the same as the private international law of England. So we'll be referring to all cases with respect to the English law. And there is one more necessity of private international law, and that is comity of nation. Comity or courtesy is not a matter for judges to adopt in deciding cases. It is a matter of sovereigns in their mutual intercourse. Comity is not compatible with the judicial function. So, as Cheshire points out, the application of foreign law implies no act of courtesy, no sacrifice of sovereignty. It merely derives from a desire to do justice. So, this is very important that the Cheshire has pointed out. The application of foreign law implies no act of courtesy, no sacrifice of sovereignty. It merely derives from a desire to do justice. So the various justices have given us with various definitions of private international law, and here private international law may be defined as the part of the municipal law of a state which has to be applied by the court in deciding cases which contain a foreign element. So this definition includes most part of the definition, various definitions of private international law, and this has been described by Batty as the rules voluntarily chosen by a given state for the decision of cases which have a foreign complexion. So that is with definition of private international law. And what is it related with? Private international law is concerned with the choice of jurisdiction, the choice of law, and recognition of foreign decrees. So the functions of private international law is threefold. What are these? That is the jurisdiction, the choice of law, then the third one is recognition as well as enforcement of foreign judgment. So the question of jurisdiction has to be examined from three angles: from the point of view of the plaintiff, from the point of view of the defendant, and from the point of view of the subject matter of the suit. So here we have to check the subject matter of the suit too. So while we are considering the stages of a case with foreign element, the function of private international law is threefold, but when it comes to the stages of cases with respect to foreign element, we have 4 stages, that is these 3 functions as well as one more stage, that is the classification of cause of action, because while deciding jurisdiction that is also important. So classification of cause of action is also included in the stages of proceedings of a case with foreign element. Now, to exercise jurisdiction, residence in the country is not necessary. That is also important. To exercise jurisdiction, residence in the country is not necessary. Now, certain persons and certain subject matter which are exempted from the jurisdiction of municipal courts shall be considered, and they are foreign sovereigns and their representatives and the properties of sovereign. Then what else is important? Now, the Indian private international law requires the court to decide formal validity of marriage by applying the law of the country where the marriage was celebrated, that is lex celebrationis. Now, in this case, the American law, the law that is the I said that private international law is different in each country. So this is a perfect example for it. When it is a dispute between marriage, when it becomes to a dispute between marriage, first we have to consider if the marriage is a valid marriage, and for this we have formal validity as well as essential validity. While considering the formal validity, the Indian private international law goes for lex celebrationis, that is the marriage valid as per the formalities of the place where the marriage was conducted. Now, with respect to American law, the law indicates or chosen is lex causa. So that is the difference between the Indian law as well as American law, and this is yet again different in Australian law. Now, the distinction between private international law and public international law. Public international law is distinct from private international law. Public international law is common to all nations. This is not true of private international law, which is different for different countries. Private international law is a part of municipal law. So again and again, don't mistake private international law as a international law. It is a municipal law, part of a municipal law. Now, as a rule, there is no international law in private international law. Private international law is concerned with particular kinds of disputes between individuals which arise in municipal courts, disputes which may fall under the jurisdiction of two or more states at the same time. So that is where private international law comes into action, and private international law is also based on the principles of natural justice. Now, what was the aim of the private international law? The aim includes, because there was always a different municipal system of law with conflicting rules. Each country has their own municipal system of law and it may be conflicting rules. So the result of a case may depend upon the forum chosen by the litigant, that is when there is a forum selection. Now, the aim of the private international law is to avoid this consequence as far as possible by applying the relevant foreign law instead of the lex fori. Lex fori is the law of the country where the court is situated. So when there is a forum selection, when the lex fori is applied, it may lead to gross injustice, and to avoid such consequences we need the private international law. But yet again, the private international for each country, law for each country is different. So was this aim completely satisfied? So there was always a conflicting between the private international laws of each state. So to avoid this, there was we could say that we have to find two solutions, or we have to implement two solutions. The various studies have come up with two solutions, but it is not completely implemented. It has its own obstacles for complete implementation. And what are these? So the lack of unanimity in private international law, different countries can be reduced in two ways. How can it be reduced? One is the unification of internal laws of various countries. The first one is unification of internal laws of various countries, and the second one is unification of the rules of private international law. So when there is a unification of the internal laws and when there is a unification of the private international laws, it becomes the same for all the countries, and thus we can apply it in a vast or wide range. Now, the Indian private international law, we follow the principles of English private international law as the case of torts. So this is largely dependent on the case laws. There have been some statutory changes in certain areas of private international laws in England, but not such statutory reforms have been made in India. But this scenario might change depending on the situations or the cases that come up. So far, private international laws dealt with India is comparatively very less with respect to the English code. So we haven't adapted to the newer statutory changes in the English private international law. Now, Justice Chandrachud has made an statement in Satya versus Teja Singh, that is a 1975 case, and Justice Chandrachud has made a statement in this case, that is, there is no system of private international law which can claim universal recognition, and that explains why Cheshire, for example, says in his book that it is concerned solely with the system which obtains in England, which exists in England, that is to say, with the rules that guide an English court whenever it is seized of the case that contains some foreign element. So that is with the definition of foreign element, the necessity of foreign element, why it was brought, the aim and the obstacle it faced to satisfy the aim of the private international law, and what two remedies can be brought or implemented to face this conflict between the private international laws of the state. So that is with this session. Thank you for listening. Please do like, and if you have any feedback, do drop a message in the comment box. I will surely reply to it. And if there is any correction that you suggest, please do mention the same also in the comment box. I'll be happy for your feedback, and do subscribe to my channel, and thank you for listening.